Are you responsible for paying the debts of your loved ones? Hi, my name is Alec Osland, and I'm an attorney at Yanowitz Law Firm, where we've been assisting families with wills, trusts, and probate for over 30 years. So what about that debt? Do you need to pay it? Are you required to pay it? Under Minnesota law, generally, although not always, the answer is no. You are not responsible for paying the debts, but the decedent's estate is responsible for repaying those debts. Now, first, we have to talk about assets before we get into debts. The assets, they may pass to the beneficiaries directly if there's instructions on how that account passes, if there were beneficiary designations listed, or if there is a surviving joint owner, those assets are going to pass to those individuals because there's instructions for how those assets pass. If there's no beneficiary designee listed on an account or there's no surviving joint owner, the assets fall to the decedent's estate. If the assets in the estate have a value over $75,000, a probate is going to be required to transfer those assets to the beneficiaries. With probate, creditors can then file a claim into the probate, and the personal representative is responsible for satisfying those claims. After all of the claims have been satisfied, at that point, the personal representative will distribute the assets, out to the beneficiaries. So what happens if there's more debt than there is assets? In that situation, the estate is going to be considered to be insolvent. And with insolvent estates, there is a statute that outlines the priority for the creditors on who gets paid first. And so that order of the priority, any expenses that arise, after the death of the decedent, such as funeral costs to administer the administration, such as like attorney's fees. Next is going to be federal taxes. Then that is followed by any, medical or nursing home expenses during their last illness. That's followed by medical or nursing home expenses during their life. And then there's going to be, debts and taxes, and with preference, under Minnesota law and state taxes, and then all other claims. So there is an order for insolvent estates of who gets paid first. So it's very important that you don't just start paying all of the claims as they come in if you are going to have an insolvent estate. Now, there are exceptions to the debt rule, as I mentioned above, with that famous attorney answer of, well, it depends. If the debt is owned jointly, for example, if there was a co-signer on the note, or if there's a credit card that's in multiple people's names, that joint owner, they may be responsible for the entire debt. Further, Minnesota law requires a surviving spouse to pay for necessary medical services for the deceased as well. So essentially, the biggest takeaway you can have from this video is that before you pay any debts of a deceased loved one, you should speak with an attorney to make sure that you are actually required to pay that debt. Because if you pay it and you're not legally required to, you're most likely never going to get that money back. So I hope you enjoyed this video. Make sure you subscribe to our YouTube channel to find out when we post a new video. Thanks. Have a great day.